All right. Thank you so much for joining us, everyone. This is an Alliance for Higher Education in Prison community conversation, and today is the Jailhouse Lawyer Legal Learning Behind Bars. I'm Corinne Cannonberg. I'm the Communications Director at the Alliance, and I'm joined today by Calvin Duncan, who is the author of Jailhouse Lawyer. Also on the call is Sophie Cull, who is another co-author of this book, and she'll be in the chat answering any questions you might have, sharing some resources, and can join us in the Q&A. But the conversation for the most part today is going to be between myself and Calvin about the book and his experience learning the law behind bars. So really looking forward to this conversation. Thank you for being here, Calvin. And yeah, without further ado, let's go ahead and get started. Calvin, would you mind introducing yourself, saying a little bit about what you're currently doing and a bit about the book and your inspiration for writing it?
Okay, thank you. I'm Calvin Duncan. When I was 19 years old, I got arrested for a murder that I didn't commit. And while in, you know, prison, I was told several things that I would get into later. But I ultimately was convicted and sentenced to life in imprisonment. And while in prison, trying to help myself, I started learning the law and started helping other people. When I got out of prison, so for the whole while that I was in prison, I helped people on their cases. I became what's easy to grasp as a jailhouse lawyer. And then I got out of prison, and then I started I created the Light of Justice, which what I'm doing that right now. And I help people in prison get access to the courts. That is, I help them get access to their records, updated case law, legal material. From time to time, I go back to the prison and teach. While in prison, I taught. So once I got out, I know I wanted to help the people that I left behind. So I pursued my undergrad degree. I received a bachelor's degree from Tulane University in paralegal studies. Then I went to law school in Portland, Oregon, Lewis and Clark, where I received my JD. And then I returned back to New Orleans to continue to help the people that I left behind. I'm a co-author of the Jailhouse Lawyer, and yeah, and I just help people that's coming home from prison. And also people that's in prison. That's pretty much my bio. That I'm a very busy person and helping people that's still in prison.
Wonderful, thank you. And for those of us on the call who might have joined last minute or haven't caught any of the press related to this book, I just want to show us the book that we'll be referring to, The Jailhouse Lawyer, written by Calvin and Sophie. And so my discussion today is going to be a lot of questions about this book. So I will be referring to things in the book, and I recommend that you all get a copy and read it. It's excellent. But we're also going to be talking more generally about what it is to learn law behind bars and who the folks are who are commonly referred to as jailhouse lawyers. So, Calvin, I want to start kind of in the beginning in this process of you becoming a lawyer and learning the law. You talk in the book about the difficulties of learning law while incarcerated at the Orleans Parish Jail on pretrial detention, and how it was more difficult to learn the law while in jail versus prison. So, could you say a little more about what learning the law on your own in jail looked like in those early days, and then also about filing and winning your first motion?
Yes. So once I was extradited from Oregon, I was arrested in Oregon. I was in the job court. They arrested me and they transported me, extradited me to New Orleans. And they put me in a Orleans Parish jail. I was later placed on a unit with guys that already had the death penalty. hundreds of years, had already been in prison for many years. And when I would tell them about my case and I would tell them that I was innocent, all of them told me that I was going to get the death penalty. Because they say, look, you got the same lawyer that I had. You got the same judge that I had. I had my judge's name was Frank Shea. And one time he had 6 felony jury trials in one day. So they had the same lawyers, same prosecutors, same judge. And it was telling me that I was going to get executed because the victim in my case is white, and the main witness in my case, was a white young lady. And the book talks about, the crime. So I asked the guy. I began to ask the guys, how can I help myself? And my friend Big Duggar told me that I had to become a lawyer, but the only thing I had was like a ninth grade education. And so the big problem was that we didn't have any legal material. We had, some every now and then I would write people on the outside to get Xerox copies of cases to try to learn how the system worked, how my trial was going to be conducted. And the whole idea was to kind of save myself from the death penalty and, just from not being convicted. So without any legal material available in the parish jail, no law books. I started creating. I always say I used to enjoy and like when wealthy people got arrested because they had the big shot lawyers, and every now and then, whenever a newspaper article would come out about their case, they would put some part of the law in that newspaper article. So I started creating my own law book using those newspaper articles. But then when I used to go to court, I saw on the desk, or the prosecutor desk, the defense desk, they had a criminal code. So I figured that's the book I need. But we didn't have access to those to that the law books. So what I did, I prepared a motion and I titled it "A Motion for a Law Book." And I always say that in law school I would have got an F for that, for titling the motion, and I titled the motion "A Motion for a Law Book." And I explained to the judge, "Look, I'm charged with a capital offense. My lawyer's not coming to see me, and we don't have no legal access to material in the parish jail." I sent it to the wrong court. I sent it to the Supreme Court, and they say, "Look, you sent it to the wrong court." So then they remanded it back. They granted it and remanded it back to the trial court, and I ultimately received the law book that I really needed to start studying how trials are being conducted. And then I got rid of some of my newspaper articles because now I had my actual the law book. And so that was my first motion, my handwritten motion, a motion for a law book. And I always say, once I got that law book, I know I was a lawyer at that time.
I love that. Um, After your conviction, you were in the Orleans Parish Jail awaiting appeal, and continued to be a lawyer, filing numerous suits, advocating for both yourself, and also for others. Um, could you say a little bit more about why people in the jail called you the Snickers lawyer?
Yeah, so they had several older guys that was in a parish jail that had came from Angola, Louisiana State Penitentiary. And the meat that they were serving us in the parish jail, it was real tough. We called it horse meat. And watching them older guys trying to chew their food without dentures, one of the things I would do is file a 1983 actions. And I would argue that the prison should provide them with dentures because it's a violation of Eighth Amendment, because it's really a cruel and unusual punishment for those guys to try to digest their food. So I started actually helping the guys with on their civil cases. But then it became known that if you wanted my help, if you gave me some candy like Snickers, I work on your case. I immediately drop everything I'm doing just to work on your case. And so I got the reputation as being a Snickers bar lawyer, because they knew that if Calvin, he's busy, but if you bring him some candy up, he'll help you. And so that's how I got the nickname. The reputation is called. is the Snickers bar lawyer. Yeah.
And it was really incredible the amount of legal work that you were able to do in the Orleans Parish Jail without the kinds of resources and access that you would have later. Um, so I want to hear more about that. Once you were in Angola, you discovered inmate counsel substitutes, which is the more kind of technical term for what people might know as jailhouse lawyers.
Yeah.
Um, who were they? And what was different about learning the law in Angola as compared to the Orleans Parish Jail?
Yeah. So at before my the night before my trial, I'm gonna go live back a little bit. Night before my trial, my lawyers came to see me, my trial lawyers. And that was their first time actually coming to see me. And they only came to see me to see if I had any clothes to wear. So after the government had presented their case, I was capitally charged, the government positioned that I should be executed. The jury found me guilty. A unanimous jury found me actually, guilty of first degree murder. And then when they went into the penalty phase, then the question was, should I be executed, given a death penalty, or should I be sentenced to life? The jury rejected the death penalty in my case, and I was sentenced to the remainder of my life in the Louisiana State Penitentiary. So once I got to the Louisiana State Penitentiary, I knew what I needed. I knew what where I needed to get. I needed to get access to the law library. That's where the law books was. I had heard that they got law books at Angola at the library, and that's where I needed to get. So so I applied for the job. The job is our title was inmate counsel substitute. We actually substitute, jump in when lawyers jump off the case, we jump in. So, but I'm gonna refer to it as a jailhouse lawyer. I applied for the job, I was given the job, and the institution trained us to provide representation to the people in prison that cannot afford lawyers. And that was my job. That was my job for a total of 23 years. 19 of those years, my job was actually to help people that were sentenced to death. And so a jailhouse lawyer do everything that a lawyer does, everything. We spend all our time reading records, researching issues. We try to do some discovery through the mail, but that's a very difficult task. So we function just like lawyers, but we just can't leave the prison to go do the investigation that we need on cases. So we generally is confined to what's in the record. And yeah, everything lawyers do, we did. Some people would have said, well, man, that's illegal practice of law. I said, well, yeah. The institution trained us to illegally practice law, but back then, but even right now, it's not illegal practice in law. It's that the institution owed people in prison access to the courts, and what they did with us is train us to provide that access. But yeah, we function just like lawyers, just like lawyers. We give people legal advice. We prepare for pleadings. We develop strategies. And when we reviewing the people cases, if we determine that that person wasn't afforded a fair trial, we actually help them litigate their case. In the process of reviewing a case, if we determine that a person is innocent, then we contact the Innocent Project New Orleans that that because they are in a better position to actually do the investigation that's needed in innocent cases.
And I'm so curious. I mean, already you had experience filing motions and working with people on their cases, but what did the training look like when you were fairly new as a jailhouse lawyer? Like, how did it feels like law is such a steep learning curve, regardless of what angle you're coming at it from. So what did the training look like in those early days?
Well, initially it was trial and error. While I was in the parish jail, uh, Every now and then a lawyer might kind of like send a sample copy of something that they had prepared that we would write. So everything basically was trial and error. I'm gonna give a story about one time I went to the federal court and I told the judge, I said, Your Honor, I was trying to prevent the sheriff lawyer from impeaching my credibility by bringing up the fact that what I was in prison for. So I filed this motion to prohibit them from actually bringing up the reason why I was in prison. And so I went to court. I said, Your Honor, I prepared this motion you hadn't ruled on. And the judge was like, okay, tell me what is the motion? I said, you got it. And she said, well, what is the motion? I said, it's a motion of lime, Your Honor. And the judge said, lime. And then the clerk came to see it and saw what it actually was. She said, Your Honor, it's a motion of limine. I said, that's the motion I'm referring to, Your Honor. So it was basically trial and error, trial and error. Some of the senior counsels, jailhouse lawyers would teach us. Then we would have people from the outside. Some judges would come and teach us, conduct training. Lawyers would come in and conduct training. At the institution had a requirement that we continue to have, we had 12 hours of continuing legal studies every year. So in Louisiana, the institution, believe it or not, they actually embraced it, access to the courts, helping um, people that's in prison learn the law so that we could actually help people in Louisiana that cannot afford a lawyer. Because in Louisiana, you're not entitled to a lawyer after your appeal process. You're on your own. So they train us to be that lawyer. That's why the initial title was inmate counsel substitute. And I'll get in more details, so the difficulties was not having access, not having education, because a lot of us, we dropped out of school, like me, in ninth grade. We didn't have the full year of college degrees. We didn't have we didn't have the 12 years of a graduate, um, 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 not undergrad, but elementary schools. We didn't have the 4 years of college. We didn't have the 3 years of law school and the many years of legal practice. The only thing we had was the desire to help one another. That's what we had that was going for us. And we was in a messed up situation because I was reading cases, reading books that was saying that every liberty that we got in the 60s and in the 70s, that there was a movement to take all of those rights back. And I'm watching this happen. Now we definitely see it in action. They was starting in Nixon time. And so I'm reading these books that's saying that they're gonna change all of the laws, those cases that gave us the liberties, not just people in prison, but people on the outside, they're gonna repeal them. It was a movement. And I'm watching this in jail. So what we did was we was trying to help each other, telling stories about we can't get our records, doing the best that we could. Um, so that going right back to some of the difficulties that we was experiencing, that we had a whole government saying, I'm going to strip all of those liberties that was handed down by the United States Supreme Court. I'm going to re, I'm going to reverse them by what? Appointing Supreme Court judges that's going to bring us back to the 1930s and 40s. And so we witnessing this. So the only thing that we could do is push back and saying that no, a right to a fair trial should continue to be a liberty that everybody enjoyed. The right to counsel should be a liberty that everybody um, should continue to enjoy. Um, I probably got off the topic, but those was a lot of the difficulties. What we do as counsels, jailhouse lawyers, without the education, without lots of access to legal material that people on the outside, we just took whatever we had and did our best, and we taught each other. So in prison, I taught a law class for 15 years. I was the nutty professor. They would say, "Oh, he come." Sometimes they used to say, "Well, who are you today? Are you Thurgood Marshall? Are you Rehnquist? Or who are you today?" And I'm like, "Well, I feel good today. I had my coffee. my sugar level is good, so I'm going to be Thurgood Marshall today. Yeah, but we taught each other, and the reason why we taught each other was to empower the next generation.
Well, yeah, you predicted my next question too, because I want to spend some time talking about that peer-to-peer learning. And there's a lot of folks on this call who are educators, professors, um, and I'm really curious what it was like for you to um, spend so much time learning about the law, learning from your peers, and then eventually taking over a leadership position and teaching others. And I'm also curious, for example, who you modeled your teaching off of. I think a lot of us who are educators can think of people in our life who we look to as role models for teaching, and we emulate their teaching styles. Um, and so, yeah, I'm curious what that was like for you teaching.
So while in prison, I read this book called 1L by Scott Turow. That he wrote about his first year of law school at Harvard. And I used to know this guy's schedule. I know his class. I know his professors. I know everything. And so in there, it talked about the Socratic method. So when I start teaching based upon the Socratic method. And but I don't know who I didn't model my teaching on. I don't know. I don't think I modeled on anybody. But what I accepted was that all of us didn't have the education. So I had to learn how to explain things in a very simple way. I had to accept that a lot of these concepts, prior to the person that never experienced prison, they fine. They concepts you could quote them like finality, federalism. What it None of that helps my students understand that how does the state government get to erect procedural rules to keep us out of court, and the federal court has to respect those state decisions that procedurally defaulted the case. Well, my students weren't going to understand that missing a deadline is more important than your liberty. If you one day, like it's a case Coleman versus Thompson, he missed the deadline by one day, and they executed him. And it's a question about his guilt or innocent. But the case started off with this case is about federalism, the respect that the federal government owed the state and its procedure rules. My students wasn't going to get this contradiction because we hear growing up that the federal government is protect your rights. The government, if somebody try to trample upon your rights, that the Bill of Rights is to protect the people that's being accused. And we learn this stuff in school, but then we go through this process where it look like all these procedural rules is keeping us from getting a fair trial and convicting people based upon non-unanimous jury verdict. So my students weren't going to get that contradiction. So I had to actually explain it in a way that they would be able to learn it and not get depressed, but learn it. And so I had to, take that in consideration because I never wanted people to give up hope. That just because of the United States Supreme Court say that it's okay to execute innocent people, we ain't believing that shit. Period. No disrespect. That ain't happening. Just because they say that um, the state has a right to convict us based upon when non-unanimous jury verdict. That's what the judges say, but it's wrong. So it wasn't no model that I modeled behind off of, but I had to accept that I'm talking to a group of people that now believe in the system, they believe what we was told in high school, and that is still true. And so I had to actually go, we read cases together. And right now I teach at Tulane, and from going to, my experience in law school, I make sure that some of the confusing concepts or explained in a way that we could fully understand it. Um, so yeah, that's the model. If I modeled after anything, it would be taking into consideration that we didn't come from that educational background. And also the fact that, our upbringing has really, you know, really prevents us from understanding concepts because of the abuse that we experience as kids, the neglect, and also the conditions in prison, being in prison, all of the trauma that we experience that really disfigured our brains, that it prevents us from making healthy decisions and learning things because of those. Um, so I had to take all that in consideration, that we come from a different background. We 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 come to this criminal justice system having experienced some tremendous abuse. And then now we are being abused by the system. And so so I had to reconstruct, like, what is finality? Meaning, look, we just got to meet our deadline, stuff like that, as opposed to getting into the weeds that finality supports the plaintiff. It brings a final conclusion. Well, that shouldn't apply to us because our conclusion in criminal cases is never final because the government generally withholds evidence from us in Louisiana. And it's difficult for us to get our records. So when we do get our records, they say, oh, finality, you missed your deadline. You had 1 year to find this information. And if you didn't find it, okay, you spend the rest of your life in prison.
Yeah, and that's some of the most difficult and most important work of teaching is, you know, digesting these extraordinarily complex pieces of information, um, to be understandable to students. And I think, your point too about the reality of learning law while incarcerated is that you're learning about these things that are directly impacting you, which is very different from the way that many other people learn the law, very separated from the criminal legal system. And I want to talk a little bit about that, your future experience learning law. So if we can sort of jump forward in time a little bit, following your release in 2011, you got an undergraduate degree and went to law school, and you graduated in 2023 with a JD. And the very end of your book mentions that in your first semester of law school, the professor had the class study a case from Angola that you yourself worked on personally. Um, So I'm curious, what was it like going to law school after having spent decades learning the law? Um, and also studying the very things that you had worked on as a case study in class.
Yeah, so this particular case, we was learning is my professor was Robert Klonoff. He's good. I think despite all the work we had, everybody made sure that we was prepared for his class. Just the way he taught, he was awesome. And so we was analyzing, he was teaching us about rightness, those standing concepts in law school, that the case is not right. And so we was, the case, it was a Fifth Circuit case. It was, it looked it good. Nobody would question the decision. We was learning rightness. But what was behind the case was, what was these guys in prison fighting for? What was it what was our complaint? Well, we was working in the fields. And when it's time to relieve ourselves, it was no porta potties out there. And this the food that we eat, and this the food that they're selling to the population. And we got to do the number two and do the number one. And so we was fighting for porta potties, somewhere to relieve ourselves. And so what the institution did was say, "Oh, we're gonna use these procedural rules to kick them out of court." So what they did was they gave the main plaintiff a duty status that took him out the field. So what we did in prison, we hurry up and had to file ARPs to try to get Jern as a plaintiff. And so in the case, The case didn't tell us really outline. We was fighting for pot reporters. And the system, what the institution did was to kick us out of court. They removed them from the field, and the Fifth Circuit say, well, y'all have no complaint. This guy is no longer in the field. And so we never got porta potties. But my professor did not know that I had been in prison. And so when I was telling him, I worked on that case while I was in prison. And he was like, whoa. He didn't ever get any clue that I had been in prison. And I was actually, but yeah, it was Professor Klonoff. He was amazing. But we learned, so reading these cases and seeing how they are being taught from an academic standpoint, I knew that it was a disconnect. The people that's being harmed by these decisions is never thought about. And the public is never hearing about these decisions. So one of the things that really did, Oregon, I love Oregon. As a matter of fact, that's the thing that's sustaining me all my days in prison, 28 and a half years, was knowing that I could probably go back to Oregon to go to Mount Hood. But what really disturbed me in law school was that disconnect. It's the procedural rules. How do we derail cases as opposed to what is the problem and can we solve this problem? And then after law school, I said I wanted to go home. I want to apply for the head jailhouse lawyer job at Angola in the prison and teach the other jailhouse lawyers in a very not so much harsh way about how people that's reviewing our decision, what are they being taught and what are they looking for, and how we can actually move the discussion from procedure rule to finding out what happened in this case, as opposed to, oh, you didn't meet your deadline, oh, you filed the wrong pleading, oh, you used the wrong paper. Those rules is always going to work to our disadvantage because we're in prison. We don't know the rules. We didn't go to law school. Lawyers that didn't go to prison got the education, got the law degree, practice law. They have problems meeting those same rules. But then they telling us, but a lawyer on the outside, when they miss the deadline, they go back home. But we have to remain in prison. And the court generally say, because you didn't comply with all these procedural rules, you have to die in prison. Yeah. So law school, I loved it in my law school. I loved Lewis and Clark. I love the professors. I love the things that I was learning, but it was very depressing to know that that's why I had to spend 28 and a half years in prison, because we have this attitude that procedural rule trumps liberty, life, property, and they asking us in prison to become more than the professors. They asking us to become super lawyers. And so, and that's why I go back to the prison to teach, you know, because the rules that they're applying to us should not apply because of our situation in prison. I don't know
Yeah,
if that
thank
answered your
you.
question. Yeah.
Yeah, absolutely. I think that's such a huge takeaway that's important for everyone on this call to think about is that disconnect that you're talking about. I want to ask you one more question before we turn it over to the audience questions. As I mentioned, there's probably a lot of educators on this call. They make up a large percentage of our higher education and prison community. And I want to know what you would like to share with educators. Like, what are your takeaways from, in particular, the peer learning model of
Yeah.
people in prison and in other environments teaching each other? And what can educators who are teaching in different models learn from that? What are some big lessons that we could take away?
So I think educators forget how difficult it was to learn the stuff that they are teaching. It didn't come natural. They struggled to get it. And I think over the time they forget how hard it was to learn it. And so what peer group, what we did in prison and how we teach one another is that we don't forget how hard it was for us to learn it. So we have, in order to learn it, we develop skills that make it very simple. And I think educators forget how hard it was to get it. And so then, I think if I had to say anything, if I had to suggest, I just would say I hope that when it deals with us in prison, take in consideration that we have been through a hell of a lot that has really twisted our ability to grasp things quickly. Be patient with us. Second of all, is that um, this stuff is hard. Learning a new thing is hard. And it's no different from people that's in prison. It's just that people from in prison generally have some, have had a lot of trauma that has really interfered with their ability. But what we focus on is I want everybody in my class to understand you have 1 year to meet that deadline. That 1 year does not start when you get the mail. It starts when they handed the decision. And I would keep on because and the 1 year would be about the finality and the federalism of the procedure rule. But the peer support is that we understand how hard it was to learn it. And therefore, we are always reminded that the people that we try to help in prison is struggling too. So we figure out how to make it a little easier. So when they have to teach the next generation, that they would be more considerate. First, before you even start, I would say the peers, we understand from the very beginning, whereas the people on the outside don't. And so for people on the outside, I would suggest that you take into consideration your audience. We do it on the outside. We know think about your audience. Your audience are people that's very little education, but we want to learn. We want to learn this, whatever it is, whether it's learning how to add 5 plus 5, um, 25 divided by. I used to teach um, GED classes, and one of the things I used to struggle with, not struggle with, but I found easier how to teach my students how how to divide. And so say it 25 divided by 5. And then I would say, well, now 5 divided by 25. They want to throw the big number in the box. And then I immediately realized, oh, they're not paying it. We got to get it. It's the number that's being divided is going in that box, whether it's big or small. We practice learning, listening. Then we could then we'll see. And Lewis and Clark, I love Lewis and Clark. Some of them professors knew exactly what I was struggling with. One of my professors said, Calvin, oh, you reading the whole case? I said, yeah, I read the whole case. Stop reading that whole case. I only read what's in the book. And I said, oh, that's why I was getting confused. I was reading the whole case. But just paying attention that peer support learning structure, we always being mindful how difficult it was for us to learn it. And we knew that our job was to make sure the next person learned it, not
Yeah,
going to the next step. We had to make sure that they get it as well.
absolutely. Thank you. That's great. I
And I
want to
think
turn us over.
I got 2 minutes before 45. One of the questions that you had was one of my favorite cases. I'm gonna tell y'all what my favorite case. It was a guy named Juan Smith. He had 5 life sentence cases and 3 death penalty. It was the 5 life sentence cases that convinced the jury to give him the 3 death penalty. Because he had the death penalty on the 3 convictions, death penalty, he had a lawyer. But the 5 life sentence cases, he didn't have a lawyer. And that was the evidence to convince the jury to give him the death penalty. So the only thing he had was a jailhouse lawyer, Calvin Duncan. I didn't have his records because in Louisiana, they say that people like me are not considered to be a person for the purpose of getting the records. But when I read his appeal, I knew they had Brady material. That Wine was possibly innocent of those 5 life sentence cases. So I filed a motion, a Bear Brady claim, and I said, look, I don't have the evidence, but I know that same prosecutor that prosecuted Wine, that same judge, I knew they got evidence that they didn't turn over Brady material. And I filed it to interrupt before he missed his deadline. In that case, those 5 life sentence cases went to the United States Supreme Court, and he won by 8-1 vote that the government withheld Brady material from him. As a result of winning those cases, the cases Smith versus Cain, the 5 life sentence cases was vacated, and then because it was the key evidence in the death penalty case, his 3 death penalty cases was set aside. So that was my favorite case because without his records, only thing he had was the jailhouse lawyer, and we won. We won against impossible odds. That's my favorite case.
Thank you.
145.
Yeah, we're gonna go over some questions from the audience here. What has changed or not changed for people in Louisiana in terms of access to the courts since your release from prison?
So, good question. We still not considered to be people for the purpose of public records, but because I'm not in prison, guess what I am? A person. So I go get their records, but when I try to go get their records, our criminal district court is so dysfunctional. They give people runarounds and runarounds. The records are all messed up, and once the person missed that deadline, um, they barred from court. They got to spend the rest of their life in prison. So I'm running for clerk of court. I'm running for election to be the head person to make sure that people have access to the public records. So what has changed now is that we have a governor. You know, we have a people that's in authority that is just set on taking liberties away from people that's not in prison, people that's in prison. So all the progress that we made, the non-unanimous jury verdict, that was a success. The United States Supreme Court, working with the jailhouse lawyers, we got the case to after 23 times tries. United States Supreme Court finally said that non-unanimous jury verdict convictions is unconstitutional. However, Louisiana has said that those people that was convicted a long time ago should die in prison. Oregon say no, they shouldn't. Oregon has granted them new trials. Louisiana said no, they should die in prison. All of the progress we made under the last administration was taken away from us in 14 days when we got a new governor. So it's still a struggle to get the records. So if anybody wants to come to the South to help us get records, we welcome you.
Wonderful. I also just want to mention too that just a reminder for folks that might have joined us late that
somebody put the in a text Teague versus Lane. Well, Teague versus Lane, when you read the opinion, you might say, oh, it's not that bad. But the consequences of Teague versus Lane is that people in prison would die. The concept that comes from Teague versus Lane is that once your conviction is final, a new decision that comes out that tells us that we got it wrong, you still should die in prison, although you was not afforded a fair trial. That's Teague versus Lane. And so I would teach my students that Teague versus Lane stands for, although we got it wrong and you wasn't afforded a fair trial, you wasn't afforded a trial at all, you still should die in prison. Yeah, I'm sorry for interrupting you. I just saw Teague versus Lane.
no, And I'm gonna go to Gunnar in a second. I saw that they had their hand up. I just wanted to remind folks that Sophie Cull, the other co-author on this book, is also on the call here. So please feel free to ask questions of Calvin and or Sophie. But first, Gunnar, I'm gonna allow you to talk. I can turn that on the webinar here if you want to ask your question. I saw that you had your hand raised.
Hello, can you
Gunner.
hear me?
Yeah, I can hear
Yes.
you good, Gunner.
Hi, Kelvin. Yeah, so it's interesting. We have a lot of kind of similarities. I was in the federal system for about 18 years from Eugene, Oregon. Became very good friends with Judge Michael McShane, who granted my
Yes.
immediate release, who's also a alumni from Lewis and Clark. He's also supported me to law school. And yeah, it's amazing the work that you've done. As a incarcerated law clerk or helping people, I'm sorry, I found it very challenging. Well, also, when somebody lost a case, it hit me in the heart. When I was invested in their case, it was really hard to have this like professional disconnect. When we won, it was amazing. I was able to get like a dozen immediate release orders, including my own, a lot of time back, won a few lawsuits. But when we lost, it just hit me hard. So I was just wondering how you processed that, because we lose a lot more than we win in that space. And how were you able to cope with those losses and in solidarity with the people that you're living with, right?
Yeah, that's a good question. So I used to train other counsels is that when you do your best and they know you have done your best, although they lost, they know they was in a fight and you was there with them. And that's how I always dealt with those losses. As long as I know I done my best, long as they know I done my best, um, that in itself brought me comfort, and it helped us, um, not give up. One of the things that we just couldn't give up. And so long as we do we do the right thing, we try hard. And then another thing, people have to, I accept and I used to train other counselors that um, we don't have a final say, so somebody else have that. That's the judge. So we generally pray that the judges have courage to do the right thing. But if they don't, we still going to have courage to present it to them. So that's the way I dealt with it all those years, was that somebody else have the final say. So I'm gonna continue to do what I do. And if they win, it's by grace of God that we do win when we do win. And when we don't win, we just got to keep on trying. And that's why, I lived in a dormitory with guys that I lost their case. I didn't prevail. But they knew that I done my best.
Yeah. Thank you for that.
Thank you for the question, Gunnar.
Yeah, thank
Um,
you.
I want to ask if Sophie's willing to join us. And let's see. Thank you. Sorry, I'm trying to. There we go. Okay. Hi, Sophie.
Hi.
Um, I was wondering, we have another question as well for both of you, and I think this could be a good close to ending question. Could you both talk about your process of collaboration on the book, and how was it to write and work together to create the book that is The Jailhouse Lawyer?
You want me to go first, Calvin?
Yes, I'd like to hear you say it. So.
Yeah, it's a great question. The book really came out of a friendship that Calvin and I created working together soon after Calvin came home. You'll tell the longer I speak that I'm Australian. I was an intern originally that ended up moving permanently to New Orleans to work in law offices supporting people on death row in Louisiana. And because of Calvin's experience working with our clients for most of his career as a jailhouse lawyer at Angola, when Calvin was released, he came to work in the death penalty offices and ended up across the hall from me, which was awesome. And we just started, you know, taking walks together to get coffee, and I would ask him questions about, you know, his life. And then we started taking these long road trips together to Shreveport, working on cases and campaigns over a couple of years. And they're like 6-hour trips each way. So I just asked questions because I couldn't believe I got that kind of time with Calvin and his incredible story. And Calvin would share. And maybe 5 years after that, we didn't really know where it would go, but I just started interviewing Calvin, recording up those same kinds of conversations one summer. And it kind of came from that. One thing I want to say is that Calvin has remarkable stories, and when you read the book, you'll know what I mean. Even for those of us who may be familiar with prisons and courts and all the craziness that happens in those places, I think there are stories in the book that Calvin told me that surprised even, you know, the lifelong capital defense attorneys in our community. And so one of my jobs as his co-author was to go away and sort of research those stories to provide supporting material and round them out. And I'll admit, sometimes I was like, this can't, I mean, when I get into this, is this really going to show up just the way Calvin described it? And sure enough, every single time it did. So Calvin's like ability for recall and just like the texture of those stories was so alive that it really like helped me figure out how to put them, you know, on paper. And we would just get together periodically and go through the writing and make sure that it reflected Calvin's memories and experiences. And it was a really beautiful time for me. Just, you know, and I think for our friendship, it just sort of emerged organically from that.
Wonderful. Thank you. Anything you'd like to add to that, Calvin, about the experience of writing the book?
I was blessed to meet Sophie because when I got out, I used to try to date and stuff. And so, you know, all my conversation was about prison and the cases I worked on. And I didn't have nobody really to talk to about any of that crazy stuff that I, you know. And so on our long trips, she would listen. She was like my first therapist in a sense. And then we developed this, you know, genuine friendship. And, you know, like even right now, I rely on Sophie and her husband Biddish for just about everything. If I'm stuck at the airport, miss my flight, I call Sophie and Biddish. Yeah, yeah. So yeah, it's just so it was God. It was God actually. God knows what I need. I needed somebody to talk to. And on our long trips, I got to talk to Sophie about it. And now we could talk to the world about it. The book is it's a really good book. It's a book full of hope and resilience. And it talks about what we can do as what one person could do or two people could do. That you don't never give up on hope because it's important that we all have it. And despite, you know, there's a lot of obstacles. There's a lot of people that don't want us with no liberties at all. They just want all of it for themselves. But it's a testament of belief that we all entitled to all of those liberties that rich people enjoy. And so the book is a very hopeful book. And it's really a lesson. It's a history lesson that we shouldn't repeat this stuff again. Although we're on the verge of repeating it, we should stop because this is what is going to happen. Innocent people are going to be in prison. Innocent people are going to get executed. People rights is going to be not afforded to them, and we should put a break on that. And that's what the book, and it shows that you keep on and keep on. And it's a good story in the end. I finally go back to Mount Hood. Yeah.
Yeah, it's a beautiful, beautiful ending of the book, and a beautiful way to end our conversation here today.
Yeah.
Thank you so
Thank you
much
all.
for
Yeah, thank you all as well.
really appreciate you taking the time to be here, for telling your story. And Yeah, we feel honored to have shared space with you and wish you the best going forward. Thank you everyone for being here with us today, for asking questions and
you.
engaging. And please do pick up the book. It's fantastic. And if you're interested in learning more about Calvin's story, it's definitely in the book. And there's also lots of interviews and more coming. So thank you again. Appreciate
Thank
it.
you.